All right. Good afternoon. I'm Prentice White. I'm one of the Associate Vice Chancellors at the law school here. I was asked to give you all a appellate litigation for beginners. Now, first of all, that was Associate Vice Chancellor Marla Dickinson's idea to call it appellate litigation for beginners. So I mentioned this as part of our discussion. I didn't know she was going to actually use that term. So since she did put it on the schedule as that, I say, okay, well, I'm committed. So what we're going to do for the next hour, and hopefully it will not be an hour, it will be a discussion of timing, a discussion of drafting motions and briefs, and then we're going to wind it up with oral arguments. As Ms. Gilbert mentioned just before we started, it's one of those things where people get a little hazy because when you talk about research and writing and library and all that stuff, people start getting a little unfocused. But hopefully we'll be able to make sense of it as we go through it. Now, first thing, timing. When we're talking about appeals, everything is based on deadlines. It's based on timing with regard to how soon you have to actually file motions at the district court to move this to the appellate court. And then, of course, the appellate court is going to give you a list of deadlines that you have to meet with them. You're going to have to be familiar with it. They're not going to, give you any heads up as you go through it. So you have to be careful about what you're doing and what court you're in. So first thing I want to mention is make sure all your post-trial motions have been filed before you file that notice of appeal. Most times it's in federal court notice, but if it's in district court, it's a motion for an appeal. You have to make sure those post-trial motions have been filed and ruled upon before you can file that motion for an appeal. And I'll tell you why that is terribly important. Second of all, if you're in the civil side, if this is a civil case, you have that 30-day window for the suspensive appeal where you have to actually post the security. You got to talk to your clients and make sure that they're aware that if you're going to take an appeal under suspensive, you got to present that security bond to the district court. If they don't have the money in which to do that, then you're left with just a devolutive appeal. But before you get to that conversation with your clients, make sure that you file your motion for a JNOV and a new trial. And I say regardless of credibility, because you may not be the one that actually brings this before the appellate court. It may be that your clients will hire another attorney and that attorney will do it. But if you don't go through the motions of actually making sure all the motions are filed and ruled upon, even if you don't think there's any weight or any credibility to it, as long as you're doing it and long as you're actually doing what you have to do, you're protecting yourself. Because if you don't, and I've seen this happen with the criminal side, if you don't file that motion and that motion for an appeal that motion for a JNOV or a motion for a new trial was vital. That was one of the things that you could have argued on appeal, but the trial counsel didn't do it. Then of course that ties your hand when you get ready to do your appeal. All right, so you got the 30-day, you got the 60-day window, the suspensive and the devolutive. We'll bring back that issue as we keep going. In the criminal side, you have that post-verdict judgment of acquittal. You also have that motion for reconsideration of sentence. Those motions have to be filed. Sometimes it is just the process, okay? Because you're doing a criminal case, you need to make sure that you file those motions just in case there is some issue there that may surface at the appellate level. You have taken care of everything. You put all your ducks in a row with regard to that. All right, and then you have 30 days from the rendition of the sentence to actually file your motion for reconsideration. If the court denies that, then you have 30 days from that date to file your motion for an appeal. And then also the court needs to advise the client in a criminal case that they have 2 years from the finality of the judgment of conviction and sentence to file a post-conviction. But that is a little ways down the road. You don't necessarily have to worry about that right off on the appellate side. Ms. Gilbert, if there are anybody that actually has any questions, I think the way I like to do it in class is the same in which I want to do it here. We can just go ahead and entertain those questions as they surface, because I don't want to miss answering any questions that may come up. All right, state civil appeals, you remember the 7 days that you have from the mailing of the notice to actually do your motion for a new trial. And then, of course, if you don't do a motion for a new trial, then that 30 days is going to start running. Or if you do the motion for a JNOV and a new trial, then it will be from the date that the court ruled upon it. And also the same situation on the appellate side, except you don't have 7 days. It actually starts to run after the sentencing. So once that person has been sentenced and you filed that motion for reconsideration of sentence and the court has ruled on it, denied it, most times they do deny it, there is a 24-hour period in which you have to, well, let me back up. Once that person has been convicted, then they have 24 hours from there before they get sentenced, okay? They can waive it. If they choose to waive it, then the sentencing can be done immediately. If not, then the court will go ahead and start putting that situation together for an appeal. But all those post-trial motions have to be dealt with. I gave you the code articles under the criminal side and the civil side in which they have to be done. Was there a question? Oh, that was you. Okay. All right. Okay. Now, for the federal side, federal civil appeals, you got 30 days from the rendition of the judgment to file your notice or notice of appeal or motion for an appeal. Most times in the federal system, it is classified as the motion, as the notice. From the criminal side, the notice of appeal has 14 days. So there is a time delay that you have to be familiar with in the event that you're going to consider taking an appeal. And I have at the bottom there, we talked about the supervisory writs in the other session. I wanted to mention when you're deciding to do a supervisory writ, you got to be careful about, do you have the time and do you have the resources in which to do a supervisory writ? Because most times that is done right at the time you're in the trial or you're in the pre-trial phase and you have a judge that made a ruling that you don't necessarily agree with, and you want to immediately take that up to the appellate court, First Circuit, Fifth Circuit, whichever one. And the court will definitely give you that option to do it, but they're not going to stop the trial. They're not going to stop certain things from proceeding. So you have to decide for yourself whether you have the time in which to actually dedicate to drafting that supervisory writ and then filing it. Do you have the time to go and start putting that information together in a supervisory writ and filing it with the appropriate federal court or the state court? So sometimes those decisions have to be made between you and your client, you and your partners, depending on the situation that you have. All right, now we get to the good side with regard to the criminal cases at the state level. I wanted to discuss the motions first. You have several motions, and I have at the bottom the answer to appeal. We'll talk about that as well. One is the enroll as appellate counsel. If you weren't the trial counsel, then if you're taking up the appeal because the client came to you and said, look, I want you to handle the appeal, you're going to have to file that motion to enroll as appellate counsel. That will put you on the list for everything dealing with that appeal at that circuit court. I've had a colleague ask me about the continuance. They've asked me about the situation is, what do I need to include in it? Well, you're going to have to explain to the court why you need that continuance. And of course, there's sufficient grounds that I have used that has always been recognized by the court is the largeness of the record, maybe with regard to the fact I have several appeals at the state court or the federal court or a combination of them. That is considered to be sufficient. Maybe you're at a conference during the time that the appeal is actually going to be required to be filed. So those kinds of reasoning grounds would be sufficient for the appellate court. There have been situations where you notice in the record that certain things are missing. You're going to have to file a motion to supplement the record because maybe they didn't include the voir dire, or maybe they didn't include the closing arguments. Maybe there was something missing with regard to some other aspect of the case. You're going to have to file that motion to supplement the record. And most times it's going to include a motion to suspend the briefing delays. Because the court reporter is going to have to supplement the record, you can't file your brief at the time schedule that the court originally gave you. So you're going to have to actually get them to suspend the briefing delays, which of course they will do that because the information that you need is vital for you to complete the appeal. Motion to substitute counsel and withdraw. That's in the event you originally started as the appellate counsel, then of course somebody else came aboard, and of course that threw you off. So you have to make sure that you erase yourself from the record as being appellate counsel, and someone else would come and jump in. And finally, the answer to appeal. Most times this happens at the civil level, where there's a judgment that was rendered. The court may have given you a certain amount of attorney's fees. You thought those attorney's fees were not sufficient enough. You need to file an answer to the appeal and have the appellate court to increase that amount of attorney's fees or whatever cost that you may be wanting to have the court to increase it on. Most times it applies to the damages. Maybe there was lost wages, but it wasn't sufficient. You do the answer to the appeal and you get the appellate court to increase it that way. And that is your Article 2133. All right, statement of jurisdiction in the brief, moving into the briefs. These are the vital parts that your brief needs to have. Statement of jurisdiction. Why is the selected circuit the appropriate court for your appeal? You're going to have to indicate why this is the appropriate court, because of maybe where the parish, where this particular district court was stationed, or maybe it was with regard to you're the appropriate circuit for this particular parish. You're going to have to indicate into that situation why the statement of jurisdiction puts the First Circuit, Second, Third Circuit as your appropriate court. Inside of that statement of jurisdiction, you're going to have to indicate what has taken place to bring it to a final judgment at the district court level. We had a trial, the jury awarded my client or didn't award my client X, Y, and Z damages, or if this was a criminal case, my client was convicted on a certain date. Then, of course, they filed the post-trial motions. The motions have been ruled upon. I filed the motion for an appeal, and the motion for appeal was granted. Therefore, this circuit is now vested with the jurisdiction to handle this particular case. From the statement of jurisdiction, you go to the statement of the case. On the criminal side, you have to indicate the bill of information. What was the defendant charged with? What did they enter at the arraignment? What discovery motions were filed? Were they actually settled? Voir dire, did the jury get selected? 12-member jury, 6-member jury, what have you? And what was the results of the trial? Was there a conviction under, before the Ramos case, it was a 10-2 conviction that was appropriate, 11-1. Now it has to be unanimous. And of course, that's going to be very important that you indicate that in the statement of the case. Because if it was less than 12 jurors, then you have good grounds to get a motion for a new trial. And that's why you need to file that motion for a new trial regardless, because it is vital to your client's case. And then you end with the motion for an appeal was granted, and you indicate the date. Therefore, you have satisfied the court in understanding that this case is currently proper before this particular circuit. From there, you go to the assignment of errors. What did you see as a trial error at this particular level? Was it the introduction of inadmissible evidence? Was it the fact that your client wasn't properly Mirandized when they gave a statement? You know, all the things that you have to indicate with that. So the assignment of errors, you're writing that in a sentence format before the court. And then in the issues for review, you're going to write that in question format. And I give you an example here. Did the district court commit reversible error when it denied the motion to suppress, which permitted the jury to hear prejudicial comments made by the defendant before he was Mirandized? Okay. When you set up your issues for review, you want to write it not only in a question format, but you also want to make sure it's persuasive. You want to make sure that you lean in and show the jury or show the judges on the appellate court that the district court erred in this severely. It was reversible error, it was manifest error, whatever it is, but you want to slant the facts or slant this question towards your client. When you do the statement of facts, you want to slant the facts for your client. Everybody understands that. I mean, you want to tell it from your client's perspective. You don't want to give a generic, objective overview of the facts. And usually this is where you get to be a little storyteller in your own right. I do this all the time with regard to the criminal side. I'll talk about it in a way that my client agrees, even though I may not necessarily think that that's exactly what happened, but that's my client's version. That's the way I'm gonna actually lay it out. And then the law and argument, where you guys know you're going to have to prove through the Constitution, statutes, cases, all of that, sometimes even law review articles if you have to. You're going to have to prove to the court why this particular decision was incorrect that the district court did, and why the appellate court is the right court to reverse this and change it. And when you actually are using cases, you want to make sure that it's persuasive before that circuit. There are times when you may not have a lot in that circuit that is in your favor. You might have to reach over to the First Circuit and bring it to the Fifth, or the Fourth Circuit and bring it to the Third. It just depends on what you have. Citing those pages in the record where certain information is important, because the jury, the judges, I should say, and sometimes the staff attorneys, they're looking through these briefs and they're trying to see if everything you're saying is true. Are you distorting the facts? Because there's nothing where you cite where this information came from. But if you have the citations there, you have the footnotes, it makes it easy for them. And of course, it proves that you're being upfront with the court. And of course, write in a persuasive format. The last thing you want to do is just write a generic set of facts, write a generic argument. You want to make sure that you get this court on your side. All right. Of course, you have that conclusion. Must indicate what you want. You want the court to remand this case for a new trial. You want the court to enter a judgment of acquittal for your client, whatever it is. Reduce the sentence, whatever the situation is, put that in your conclusion. And of course, the certificate of service is pretty much generic, is expected in every situation, motions, pleadings, whatever. The appendices is important with the appellate court because they need to know, they need to have it verified in the record that this is a final judgment from the district court. So you're going to have the minutes for the conviction, you're going to have the minutes from the verdict and from the sentence. You're going to have all that laid out, and that's going to be attached to your brief. 14 size font. Most times, I think all circuits require that. Times New Roman, legal paper, original, and 7 copies. Okay, that's just for the court. You keep one, you're going to send one to your client, and of course, you're going to send one to the district attorney's office. Now, on the back end, even though this probably should have been up front, notice of lodging. This is the document you're going to get from the circuit court that says your brief is due on X date. And that's when you're going to start counting down as to how much time it's going to take you to finish this. And you might have to make that determination on whether you do the motion for continuance, because this record is so large, this is not enough time. I got a trial right in the middle of this, so I may not be able to do this brief according to that timeline. The pro se briefing notice is something in the criminal side that you have to present to the circuit, but you also have to send a copy to your client, letting them know, I'm filing a brief for you, but you have a right to make an argument in your case if you choose to do so. And this is your way of explaining to the court that I've given this notice to my client. Your title page has to be correct. It has to have all of the necessary elements inside of the uniform rules for that circuit. They'll lay out everything that you need to have. You need to have the docket number. You need to have the actual citation for the case, who was the judge, what was the district court number, all of that, what parish it came out of, all of that's going to be laid out. And of course, table of contents, table of authorities. All of that's going to be very, very necessary. Now, for the state civil appeal, of course, some of the stuff that we've already talked about from the criminal side is going to also apply to the civil side. We talked about the suspensive. We talked about the devolutive and the 30-day, 60-day window. Motion for an appeal. When you do the motion for an appeal in a civil case, you need to indicate you're doing a devolutive appeal, you're doing a suspensive appeal. You need to indicate that. Of course, you need to discuss that with your clients. I've had a situation where my clients couldn't afford to do this suspensive appeal. So I knew right off this was going to be a 60-day appeal process for me, but I needed to explain to them why they're going to execute that judgment, even though we're taking an appeal. And if you don't have any funds from your client to actually do that, they should understand why this has to be done the way it has to be done. When you're on the civil side, unlike the criminal, where you don't pay for the record, you don't pay for any of the transcripts, on the civil side, you do. It could be upwards of $5,000, depending on how large it is. And of course, you need to become familiar with those individuals in the appeal section at that particular district court, because those individuals are going to be very important to you, and they can give you a heads up as to when it needs to be filed, okay, when your payment's going to have to be done, or if there's any problems with the transcripts or anything like that. You'll know those individuals by name, and they'll know you, and of course that protects you in the long run. Statement of jurisdiction, just as it was for the criminal, is also for the civil. Your statement of the case won't include a bill of information, but you'll have petition for damages were filed on so-and-so date, indicating that the plaintiff wanted to sue the defendant for injuries sustained from a car accident that happened at, Jefferson Parish, whatever the situation is. You're going to lay all of that out. Your assignment of errors is going to be basically the same. Matter of fact, your assignment of errors all the way through your conclusion is going to basically have the same premise, the same thing that we talked about earlier. Your certificate of service is going to also include the district judge as well as your opposing counsel. Now, on the criminal side, you can still send your brief to the criminal judge, but you're mandated more so on the civil side to do it. After filing your brief, start preparing your writ application. Most times you know what's going to be the result. If you're in a certain parish and you know this particular parish has a hard time giving plaintiffs anything in a civil case, you need to start preparing your writ application to the Supreme Court so that you don't waste a whole lot of time trying to do it. Once the decision come in, you're ready to do it right then and there. And remember to include the requisite number of copies to the clerk's office. All of that is very, very important. And I gave you these pictures with these individuals in turmoil like this because a lot of people, they're in turmoil doing appeals. And I think there are some people that would really just say, look, I'm not going to even try it. So therefore, don't even worry about paying me for an appeal. You need to find somebody else. And when I was teaching legal writing, I had students hyperventilating when it was time to do oral arguments because this is part of what you have to do. All right, let me slide this over a little bit. Now, when you're drafting a federal brief in a criminal case, you got to know, and most times this is true, 98% of the time, it is true that your cases are going to be with a guilty plea. Your client is going to plead guilty. Why? Because the chances of them getting a higher sentence if they go through the trial is going to be very, very high. Okay. But if they take their licks right now, go ahead and plead. Then when it's time for sentencing, they'll give you some point reduction with regard to the fact that you pled guilty. You didn't force the federal government to waste time putting on the trial, bringing in witnesses, so on and so forth. All right. Also, you need to make sure if you're dealing with a criminal case that you have to check all of the documents with regard to the PSR, all of that information. You got to make sure it lines up with the sentencing guidelines. Okay. So if they require a certain amount of months for this particular crime, make sure that's exactly what they're offering to your client. And if your client is eligible for a reduction, make sure that they don't forget to include that in the PSR. Yes, sir. Yeah. It's PSI in the district, but they usually have the PSR pre-sentencing report at the federal court level. I use it, interchangeably, but PSR definitely with regard to the federal side. United States sentencing guidelines. All right. Now, the parts of the criminal brief are similar to what we say in the state, but they have a few little nuances. Certificate of interested persons. That is, if you have a client who is represented through a company, and you might have one of the circuit judges who may be familiar with the president of that company, so on and so forth, they need to know up front who are the parties. Who are the parties to this case? Who are the attorneys to this case? Maybe I practice with the district attorney who was in this particular, or the United States attorney who was in this case, or maybe I practice with the appellate attorney who's in this case. I might have to recuse myself. So this gives those judges a heads up as to whether they should be on this case or not. The statement regarding oral argument, most times you may know up front, this is a case where I need to argue. This is a case where it's very important. Just think about a couple of weeks ago when they talked about the abortion case. That is a case where you know you're going to have to argue. And that was at the Supreme Court. But you may know going to the federal appellate court that you're going to have to give an oral argument. You're going to have to tell the court in that brief that you're going to schedule oral arguments for that case. Your table of contents, your table of authorities, same as it was for the state. The jurisdiction, same. Issue, statement of case, argument. Now, summary of argument is also included inside of your state brief, and it's included also with your federal brief. And the standard of review is separate from what you would do at the state level. They need to have a particular section in the federal brief that says standard of review. So you need to indicate to the judges up front, this is going to go under the plain error, clear, and what is it? Plain and clear error, something like that, manifest error, whatever it is. You're going to have to state specifically what standard of review the judges are going to have to review this under. Argument conclusion, certificate of service. The certificate of compliance is one other certificate that's included in the federal system. You have to indicate how many words are in your brief. And I think the next slide, I say it's like 13,000 words is the maximum. You're going to have to indicate what font you have, Times New Roman or whatever, Arial. You're going to have to also include what type of program you did it on. Word, most times it's a Word document. Before, back in the early part of the 2000s when I was doing WordPerfect, I would include WordPerfect as the actual program that I used to draft the brief. So it's really just kind of a cut and paste certificate. You just fill in the blanks and make sure that you include that. If you don't include it, you just look for it to send back to you. And that's going to, be more time, more effort in your part, waste of money sometimes as well. Now that we've had this COVID situation, Part N may not be as necessary. Use of the correct color for your title page. Appellate attorneys put it in blue. Appellate attorneys had it in red. Your reply brief would be in, I think, gray or something like that. It's usually in the rules where you have to do it. After COVID, you're doing everything electronic. There's no requirement for any particular hard copies to be sent. I'm guessing that they're going to continue with that for the near future. If it changes, then they'll probably go back to what it was before. That is Rule 32. So there is a possibility that you may not have to worry about doing any hard copies. That was a blessing for me because going to Office Depot and getting that stuff copied and getting it bound and spiral bound and charging them and keeping the receipts, that's tedious. So it's not as necessary anymore. 13,000 words maximum word count, 8.5 by 11, federal, of course. The spiral binding, we mentioned that. When you cite certain sections of the record, you don't do it in the federal system the way you did it with the state. You do ROA, Record on Appeal, point, and whatever page number it is. When you're dealing with the state, you would do C, trial record, page, whatever. And the appendices, for the state, it is attached to your brief. The appendices for the federal is a separate document altogether. So even though you don't have to submit a hard copy, you do have to submit a separate document to them. And inside of that record, what was it called? Record excerpts. When you're doing that from the criminal side, you got to have the indictment, you got to have the actual notice of appeal, you have to have the judgment, you have to also have any and the docket sheet. The docket sheet needs to be included in that. And it's about 5 different documents that must be included. You can always include more, but the bare essentials is those basic 5. And since you're doing this electronically, you don't actually have to sign your brief like you do at the state level. All right. So just going to be fast. I'm going to keep my promise. At the drafting of the civil appellate briefs, all the basic things that we talked about, this disclosure statement is the same as the federal case where you did the certificate of interested parties. You're basically giving the judges a heads up as to who you're representing, who are the parties. So in the event they have to recuse themselves, they can do so. And all the other things that we talked about with the jurisdictional statement, the filing dates, the timeliness of the appeal, all of that has to follow in that particular flow. Statement of issues presented for review, concise statement of the case. If you go a little further under argument, you're going to have to, and this is true with the state as well, list those arguments separately. If you have, let's say, admission of use of inadmissible evidence, if that's your first argument, you're going to have that as your A argument. Then if you got down further and you want to do excessive sentence, that's your B argument. You're going to have to separate those arguments out. It makes it easier for the staff attorneys, for the circuit judges to actually understand what you're arguing and not conflate things together. The standard of review is going to be very important to be separated as well, because each issue may have a different standard. And I know that there are judges and there are courts that will toss your case out because you used the wrong standard. Now imagine what your client is going to say about you if you made that kind of mistake and you have to explain to them, well, I used the wrong standard and that's why we lost. Well, can we refile? No, it's over. Well, it wasn't my mistake, it was your mistake. And then of course, you know where that's going to go. That's going to go straight down there to Veterans Boulevard, where you got a complaint filed against you for not handling your cases correctly. All right, last part, oral arguments. How many of you enjoy doing oral arguments before the appellate court? All right, one in the room, and I'm sure it's very few that actually like that. So when I talk to people about doing oral arguments, I tell them the same thing that I'm gonna tell you. I tell the same thing to teenagers when they ask me about having to make a presentation in front of their class. Stay calm, breathe, have a conversation with those people that you're talking about. When you're in front of the appellate court, same thing. When you're in front of the Supreme Court, same thing. Bring to the podium very little information. All right. You don't want to go up there bumbling with a whole mess of papers and briefs and bringing a copy of your client's brief, your brief, the opposing counsel. You get confused, you get messed up. You only have 15 minutes. Make it short and sweet. Get a page, put everything down that you need to say, and go from there. Cite cases that came from that circuit. Don't give them cases that came from another circuit. We don't care about them. We don't care about the Fifth Circuit if you stand in front of the First. All right. Don't read to the judges. This is a major thing that most attorneys, not students, most attorneys do. They read. They're nervous as hell. They're sweating bullets. Take a moment, talk to them, and trust me, the very first question you get is going to break that ice, and it makes it smooth sailing, because then they'll give you a time to breathe, and then you're like, okay, let me answer your question. All right. Also, if you sense that the judge is about to ask a question, but you're in the middle of the sentence, stop what you're saying. Ask them, Judge, you have a question for me. All right. And then, of course, that's going to be more important than what you have to say, because this is where that judge is, and they want to make sure that they understand your case. If you have any weaknesses in your case, start with that. That's the very first thing I want to jump out the gate. All right. When I have a trial with a client who has a criminal record and that client wants to testify, the first thing I start with is, have you had any convictions in your past? Do you have a record? Yes, I do. What is it? What were your sentence? What happened? And get that all out on the table. So it is when you have a argument you have to make before the court, bring up those weaknesses, but also position those weaknesses that it's not dispositive of this question. I still prevail. I still will have the better argument, Your Honor, even though I have this particular weakness, or even though I have this particular bad set of facts, if you will. We talked about making sure you cite the appropriate cases. Welcome questions. I know attorneys who don't like to answer questions from the judges. They don't like it. They like to finish their statement. They overtalk the judges. Of course, that's going to go how that's going to react to them. You want to welcome the questions, and you don't want to appear to be frustrated when they ask you questions. If you guys listen to the Supreme Court arguments on the abortion case, you notice that they were actually going over the attorney and just cutting her off, and some of them were kind of raising their voice a little bit. And you gotta make sure that you kind of bring the temperature down when you see them getting a little frustrated. All right. So that's one of the things that you don't want to do inside of a situation where you have to do oral arguments. But you do want to put your opponent on the defensive. You want to make sure that you put your opponent as the bad guy here. Yes.
You know what I think?
Mm-hmm.
I think a lot of the fear.
Oh yeah.
He's stupid enough to put this whole argument in the brief. But I don't put all my case law in the brief because I know it's not. I would advise you to write a brief. Don't put all of your ammunition in the brief because that's how when I get to the podium and I say, yeah, you read what he wrote in his brief, he cited this case, that case. Look at what I tell you in my case. Mm-hmm. So that'll reduce the fear. You know what his case looks like.
Right. Yeah. Right. And you say, Judge, on page 5 of his brief, right. And you sometimes it's even better to read it for the judges. He said this, I quote, and just lay it out. All right. So yes, start off with the things that you know is going to help your side, because that puts your client in a good position. You want to make sure that the judges understand how to evaluate this. And then if you have an opposing counsel that has evaded the questions, they didn't answer the question directly, they hop, skipped, and jumped over the question, you jump up when it's your turn, Your Honor, you mentioned that you had a concern with this. Let me answer that question for you. And that way it makes it like, okay, I'm being forthright. I heard what you said, Judge. He didn't answer it, but I'm gonna answer it. And the reason why he didn't answer is because this is the answer here. All right. So you want to make sure that that's plain and simple for the judges. And then another thing, the last part, I always put that in any kind of situation where I'm telling people about oral arguments. When you've made all your points, sit down. Sit down. If you use 10 of your 15 minutes, that's fine. You could reserve time for rebuttal. And if you don't need it, don't use it. It's usually better for you to make your points right up front. The judges, oh, you finished? That's the reason why I finished, Judge, because my case is very simple. My case doesn't have any complications. I don't know why the district judge ruled the way they did, but here it is. And here's my points. And sometimes you lay it out in 1, 2, 3 format. And then the judge can follow along with you. And they are pretty much happy from there. And the end. That's it. That's all, folks.
I never go up there with paper.
Mm-hmm.
And I'm not afraid to say, guess what?
Yeah. Yeah.
I don't know the answer. I tried to research. I don't know. Got allowed on that and start lying. In this case in 2013, before we will be in 2021, sir.
And they know when you're conflating the issue. They know when you're just blowing smoke. And you want to make sure that you're upfront, you're honest. And if you don't know the answer, I don't know. I'm not sure what the answer is.
Read your opponent's brief.
Mm-hmm.
Know his cases that he cited. They put 12 cases up there cited. I don't give them all my ammunition because we taught the research.
Mm-hmm.
So if your position is really founded, sometimes I'll leave my cases out because I don't want to. I spring it on them at the last moment.
And since you mentioned that, there have been moments when I read the opponent's brief and they use blurbs from certain cases. Well, Your Honor, they mentioned this case, but if you read the facts of that case is really in line with what I'm saying.
That's right.
And they brought it up.
That's why I said. So, see, people have that fear because a lot of people are afraid of evidence. They don't know how to check on it. And they're afraid that they're going to get a question from the judge and they haven't read the case. Mm-hmm. To me, spend all your time just